I'm Drew Stevenson, and this is a lecture for my Statutory Interpretation and Regulation class about the case General Dynamics Land Systems versus Cline. This is a U.S. Supreme Court case from 2004 about being 40-something and the meaning of age in the age discrimination statute. Now, I'm sorry for my students, there's nothing about dogs in this case, but I thought you would be more likely to watch the video if I used a dog picture. The case does involve tanks, though, and sometimes during downtime, Army dogs will chill out on a tank because General Dynamics makes tanks and other military equipment that our government uses to kill young people who serve in the armies of other countries, usually under compulsion. And so let's go ahead and look at what happens in this case. General Dynamics, the company, adopted a policy that they were no longer going to give post-retirement health benefits. They had been doing so up to that point. That's a nice benefit, but they were cutting costs. And they decided not to apply this policy, this new policy, to current employees 50 years old or older. If you think about it, once you're 50, if retirement age is 65, you're within 15 years of retirement. And some of these workers had planned accordingly, had based their investment decisions and savings decisions or decisions about staying with this company that at this point on the idea that they were at a company that would pay their health insurance after they retired. So it's kind of pulling out the rug from under someone who's already now is thinking about retirement. Retirement is in sight. On the other hand, if you are more than 15 years away from retirement, you have plenty of time to maybe look for a new job or change your retirement investment plans and so forth. Well, employees who were older than 40 but younger than 50, in other words, the 40-somethings who worked for General Dynamics, sued, saying that the new policy discriminated against them for being too young, in other words, because of age. Now, our statute here is the Age Discrimination in Employment Act, or ADEA, which prohibits, quote, discrimination with respect to compensation, terms, conditions, or privileges of employment because of age. Now, that would certainly cover paying for employees' health benefits after retirement. The question is about age, because the statute gives standing to sue for those over age 40. So far, so good. Our plaintiffs are over 40. But the statute overall seems like it's mostly protecting older workers from discrimination in favor of younger workers. In other words, companies that much more often are favoring younger workers. They are for a whole variety of reasons. Younger workers will work unpleasant hours or put up with worse conditions for less money. And have cheaper benefits, cost less for your group benefits plans, on and on. So nationwide, companies are more likely to discriminate against older workers, and that's why we have a statute protecting them. But the issue here is whether the statute also could protect younger workers from discrimination in favor of older ones, like arguably the company was doing here, providing a benefit for those over 40, but not for those under 40. I'm sorry, over 50, but not for those under 50. The court here says no. It does not think that the statute protects younger workers and against discrimination in favor of older workers, mostly because the whole purpose of the ADEA was to protect older workers. Now, committee hearings, this is what the court relies on. And part of why we study this case and why it's so complicated is the extensive discussion of legislative history. And the court uses some and rejects others. There's also kind of a battle of the dictionaries going on in this case between the majority opinion and the dissent. The court relies on committee hearings that indicated that the mischief at which the statute was aimed was discrimination against older workers. Remember, if you think back to the cartoon, I'm Just a Bill Sitting on Capitol Hill, that when bills, before they become a law, go through this long process where they go through the different committees in both houses, and that are a subset, a little group of people from that house of Congress. who argue about it or make revisions to the draft and hold hearings and create a pretty extensive record. And the court here relies on those committee hearings and also relies on something that I haven't, this is the first time we've encountered it so far in my class at this point in the casebook, explicit statements of purpose that were actually codified, like put right into the statute itself. And so unlike the committee hearings, this is stuff that the whole legislature had in front of it in the bill that they voted on and that the president signed. It also makes structural arguments comparing the use of the word age in different sections of the statute. So this is a type of statutory interpretation that looks at how a certain word is being used by Congress in various places in a law. And then other structural inferences like the primary purpose and the primary anti-discrimination provision limits standing to those over 40. And from that, we can make some inferences about how we should interpret the rest of the statute. In other words, if you have an unclear question in a statute, but you could interpret it in light of the clear provisions. And the provision about who has standing to sue is very clear. But remember, our plaintiffs in this case were over 40, so they had standing. The question is whether bringing a suit against because of a benefit that workers even older than you get violates kind of the spirit of the law. The court really belabors the point in this case that the available semantic meanings of the word age include not merely the number of years since birth, but also the state of being aged. And both sides in this case use dictionaries. So in other words, I could say, what age are you? And you might answer that you are 23 or 25 or 42 or 37. Or I could tell you my age, which is actually over 50. So I would have gotten the benefit. But or we could talk about age in the sense of like as you age or due to age, which usually has a connotation of advanced age or old age. And that's the problem in the statute. The court notes that language has to be read in context. So the majority writes, we understand the difference of choices and meaning that lie behind a sentence like age can be shown from his driver's license. In other words, that's the number of years that you've been alive on the earth. And the statement age has left him a shut-in, which carries the connotation of advanced age or being elderly. So this difference permitted the court to conclude that the statute actually does use the word age in different ways in different provisions. And I want to say something about this right now for my students. This is a question, a general rule of thumb in statutory interpretation that there's no agreement about, which is whether you should take a word and interpret that word with the same precise meaning every time it occurs in a certain statute, or maybe every time it occurs in a law. Judges have this, and also translators, those who translate ancient documents. In an earlier life, that was something I studied a lot as an undergrad, was translating things from ancient Greek and Latin and Hebrew, and these old classic texts, religious texts and history books. And translators have this same issue. If there's a word that occurs in the ancient Greek or Latin, should we pick one English equivalent and always use the same word? Or should we kind of vary the English word we use to translate the same Greek or Latin word in an ancient text, depending on the context? And it's a helpful analogy because judges have the same problem, not only with translating, but interpreting a statute. Should we take a word and basically just assign a defined specific or precise meaning to it and stick with that every single time? Or can we read the word every time it occurs in the context of the sentence and paragraph where we find it? Okay, so let's go back. The majority clearly thinks that we can use context. The dissent is going to say the exact opposite. So the dissent says, look, I looked it up this is Justice Thomas, and here I have a picture of Black's Law Dictionary. Justice Thomas looks it up, and the first definition is age is the amount of time that the number of years that someone has lived. And so he says that's the primary definition. And he says, look, I know I can look at the dictionary page and there's several different possible definitions, but we should just always use the first one unless the Congress tells us expressly to use a different one. And so he says and he calls this the primary definition, by which he means the first. I hope you can see that there's a problem with this. It is true that dictionary editors list the definitions in order of their frequency. So whatever the first definition you read in a dictionary definition, the first one that they list is the most common one. But that really doesn't tell you how common it is relative to the second and third and fourth and so forth. And this can depend on the dictionary you use. I have on the top shelf behind me the Oxford English Dictionary, and I think it's 19 volumes. And so if you will look up a word in that, it will go on with 20 pages, every single definition that word has ever had in any writing in the history of the English language. But some of them have occurred only once or are very seldom used. And so the problem is that if you look at this definition section I have here of age, and let's see, what's the term to above it, against the will or something like that, we might have 5 definitions. And for one of these words, it may be that a certain definition is what we mean almost all the time, and the others are like rare poetic uses. But then you could have a word that all of the first 3 or 4 definitions occur almost equally in frequency. And so Justice Thomas, though, thinks we should just have a rule that I think he just made up, that we always have to use the first definition we find unless the context sort of forces a different one. He also really wants to have a rule that we always define the word the same way within one statute. Because the majority is saying actually the word age means different things in different clauses or sections of the statute. Justice Thomas characterized the court's invocation of mischief, or the social problem that occasioned the ADEA, which was widespread discrimination against older workers, as an exercise in what he calls social history that's inappropriate in statutory interpretation. I actually think this is Justice Thomas's worst or weakest argument in his dissent, because the mischief rule is one of the oldest traditional canons of construction. And so, sure, the court talks about a widespread thing and problem in American history. And what I think Thomas is saying is that he doesn't really think it's a problem, and therefore he wants to make a rule that we should never talk about the social problem that occasioned a statute. But that is something courts have been doing for as long as we have had common law courts. Justice Thomas suggested that reading the ADEA as protecting older workers only was inconsistent with the court's reading of Title VII. This is a more clever argument, actually, which had been construed to protect not only the disadvantaged groups that the statute was primarily enacted to protect, but all persons who suffered discrimination on one of the prescribed grounds. And so just to kind of paraphrase this for my students, the idea is we have a number of federal anti-discrimination statutes, and we have Title VII that's focused on, let's say, race and gender, and then we have the ADEA, we have disability discrimination statutes, and so forth. Well and good. Well, Justice Thomas says we've developed a whole body of case law, judicial precedent about our other somewhat older anti-discrimination statutes where we've answered this question before. And so for the sake of consistency, maybe across all of our anti-discrimination statutes, we should always use the same rule. This is plausible, right? I could make this argument with a straight face that maybe we should have a general kind of approach or system for how we analyze discrimination problems regardless of the statute, unless the statute specifies otherwise. But the majority doesn't agree. He also points out, and this is really a nitty-gritty argument, that age means the state of if age means the state of being old, then the defense available under Section 632F of the statute when age is a bona fide occupational qualification is meaningless. And just in case you lost that, that's a mouthful. The statute actually has an exception for jobs where you literally have to be young, right? So if you are modeling youth clothing or young people's clothing, we don't want to have senior citizens dressed up in kids' outfits, right, for a catalog. And so if the employer can say there's actually a really good reason, a bona fide occupational qualification that we have to have mentors. If you think about something like, or I'm sorry, age restrictions. If you think about something like a mentoring program where you want someone who's in the same age range as, and maybe only a few years ahead in a process as other people or something like that, then it might make sense. And he says if age only means being old, then we shouldn't have this. In other words, if favoring someone because of age, being older, does not violate the act, then why do you need a BFOQ or bona fide occupational qualification for age being older? This is actually a clever point, but it's so specific about one small part of the statute that's not at issue in this case that, again, it doesn't carry the day or win over the majority. Let's talk a little bit more about the legislative history that the majority uses here. So one, again, I said, is these committee hearing transcripts. And the question is, how reliable are these for telling us what the statute means? Do we have any reason to think that rank and file legislators, the ones that aren't on the committee, which is the vast majority on the floor, are even aware of the contents of hearings when they vote on the bill? The answer is probably no, right? We think most people of Congress are super busy. They have their own committees they serve on, and so they don't read all of the committee hearings for every statute that they vote on. And so a lot of what's in the committee hearings and these hearing transcripts was not really in the minds, could not have been in the minds of most of the members of the House or Senate when they voted on this law. And nor do we really think that the President of the United States reads all the committee hearings, thousands and thousands of pages, before signing a bill into law, because of the chance that the court might look to those for guidance in a confusing case. On the other hand, before we throw them out altogether, maybe they're useful because they could shed light on problems that we're trying to solve or the tenor of the times. This is especially true as we get further away in time from the passage of a statute where a new generation comes up and they don't really understand what was the problem that Congress was so upset about back in that time, 20, 50, 30, 80 years ago. There's also a type of legislative history called findings of purpose that we talk about here. And this statute actually contains enacted findings of purpose that corroborate what's in the hearings. And note that Congress has started doing this more and more. They enact these findings of purpose right in the statute. They put it right in the bill so the courts have to look at it. In other words, and I think they've started doing this in response to the rise of textualism that ignores legislative history. So stuff that they used to just say, it's okay, it's in the legislative history, it's in the committee hearings, now they make sure that they put in the statute, which in a sense is what the textualists wanted. So the question then is, if Congress knows how to put its purpose and intentions right in the bill that gets circulated and that's in front of everybody when they vote, then why do we bother looking at committee hearings anymore? They know how to fix this. They know how to put it in there and resolve all of our uneasiness about how representative the committee hearings are of legislative intent. And so the fact that Congress does have these some statutes that contain enacted findings now makes other legislative history seem like second class legislative history, surely by comparison. Please note for my students that there's a difference between intent and purpose. And so the majority does something funny here. Even though they've used the committee hearings and the enacted statements of purpose, they reject a Senate floor colloquy transcript in which the bill's sponsor assured other senators that the bill would protect younger workers from older ones. In other words, they asked the very question that came up in this case. What if a company has a policy that favors older workers and leaves the younger ones out or discriminates against young people? And the sponsor of the bill said that can't happen under this law. Now, traditionally, courts would give a kind of a lot of weight to statements by the bill's sponsor, more weight than other members of Congress. The idea is that the bill's sponsor actually is really well informed. The sponsor cares about it, drafted it, or was involved in the drafting, introduces it, stakes some of his or her political capital on it, and so their name is going to be on the statute. And so they are more well informed than someone who maybe hasn't read the statute at all and is just standing up and grandstanding on the floor of the Congress, which also happens all the time if you've watched C-SPAN. So on the other hand, the bill sponsor has an agenda. They want to get their bill passed, so maybe they are sugarcoating what's really in there. The court has traditionally treated sponsor statements as solid evidence of specific intent, but here they glean contrary evidence of overall purpose from the hearings as a whole, that everything else was talking about this. Now, you came across a word that you might not have seen before, a Senate colloquy. So let's take a minute to define this. How is it different from other parts of legislative history? This is sort of a staged conversation, right? A colloquy is planned ahead, scheduled ahead. I have here an advertisement for a colloquy that was sent out ahead of time so that people could watch it. So members of the Senate or House motion to enter into a colloquy with a fellow member, and then these two members can dialogue directly into the microphones with one another without having to address their comments through the speaker of the House or President pro tem of the Senate. If you've ever watched C-SPAN or these congressional debates, you know that everything is, Mr. Speaker, I would like to respond, and please, and so forth. And so you have to direct your comments to the speaker, and it's very awkward. The other thing about these is the upside of a colloquy is because they're planned ahead, people can have their comments, their questions and comments prepared, so they can actually, so we're less likely to have an off-the-cuff answer that wasn't well thought through. They can choose their words carefully. And in some ways, that means that the statements are more deliberate. The downside is that they're more deliberate and could unplanned ahead. So if we're not going to get any excited utterances in a colloquy because it was planned days ahead of time. And if the person isn't trying to sugarcoat the statute or misrepresent what's in there, they have a chance to think about just the right words to use to get the ambiguity in there that they want, or to create a false impression. So the court here, in this case, doesn't pay any attention to, says they're not giving any weight to the colloquy because they don't like what it says. But please note that in other cases, you're going to see the Supreme Court quote colloquies. And that's why I took the time to define it. Now let's talk about the battle of the dictionaries going on in this case. Both the dissent and the majority rely on dictionary definitions, and the dissenters concede that the word age can carry the meaning that the majority follows, but as I mentioned before, they insist that we should go with the primary, the first definition after the word in the dictionary, and say deviation from that must be clear from context. In other words, let's make a rule that we always use the first definition listed in our favorite dictionary, basically. Now, but the question is, but if there is an available definition somewhere in there, even if it's not the first one, that fits better with the statute and its purpose, why do courts have to stick with the first one? Now, again, I think Justice Thomas just kind of made up this rule. We're talking about legal language. If you think about the words you had to learn in your first year of law school, like consideration, that have a technical legal sense and don't mean at all what they do in common parlance, then maybe when we are using legal terms, we shouldn't be using the first dictionary definition, which is how like it's used in common speech, as opposed to technical legal terms. I have a question of course, it's valid to question whether courts should be using dictionaries at all to resolve legal questions or interpret statutes. Are dictionary definitions even written to answer such questions? Are we taking the editors at Merriam-Webster or Random House and turning them into sort of a Supreme Court that the Supreme Court defers to in interpreting statutes? And isn't it the traditional judicial function to interpret the law and apply it instead of just looking it up in a dictionary that was written by non-lawyers for the term? So I hope you can see dictionaries get a lot of traction because it's just so easy and seems so clear and absolute, and there's nothing left to argue about. I looked it up in my book, right? And you can say, and so that's final. But if we brought in a group of linguists, they would think that this is really weird that courts are looking things up in dictionaries. Dictionaries are good for looking up a word you've never heard before to figure out what it means, or deciding whether something is fair game for a crossword puzzle or Scrabble. Okay, at this point, you're like, wow, this is a long video. When will it end? It ends now. That concludes my video about general dynamics land systems versus Cline.